Hello, guys. So, in this session, we are going to discuss a crucial topic that is understanding the constitutional rights. And as you know, rights, play a very vital role in protecting our fundamental rights under the Constitution. The fundamental rights, which are guaranteed by the Constitution, and writs are actually going to protect that. And they are very powerful tools that individual can use to seek justice whenever their rights are violated. So, when you go through this presentation and in this discussion, we will try to explore the five different types of writs: habeas corpus, mandamus, certiorari, prohibition, and quo warranto. So, let's start with the first question. What is the need for writs actually? Okay, so the need for writs is what we need to discuss first, and then we will discuss Article 32 also, and then we move to various writs. Okay, so this is what we are going to discuss now. So, uh, you see, before we getting into the details of each of these five writs, let's consider the significance of these legal remedies. Fundamental rights such as the right to life and right to education are enshrined in our constitution, but these rights are meaningless without effective mechanisms for their protection, right? So, just as we safeguard our valuable possessions, we must ensure our rights are protected from infringement. So, writs serve this purpose, allowing citizens to approach the Supreme Court or High Court for redressal. In case of violation of this, you can directly approach Supreme Court or High Court for the redressal through the mechanisms of writs. Okay. Now, let's also discuss about the difference between Article 226 and 32. Okay, so the importance of 32 we will discuss, and also I'll make it distinction between 226 as well. So these are the two essential articles which govern the issuance of writs: Article 32 and 226. Article 32 empowers individual to approach the Supreme Court directly whenever their fundamental rights are violated. Now remember, you can approach the Supreme Court directly in case your fundamental rights are violated under Article 32. On the other hand, Article 26 allows individual to approach the high courts for various purposes, including protection of fundamental rights. So both articles provide similar power. Under Article 32, which is more specifically focused on fundamental rights, making it a cornerstone of our constitutional framework. Now, what's the difference? See, the writs, there are five types. Okay, so these are related to five or multiple different aspects that I'm going to discuss in detail. So when it comes to 226, you can approach the High Court for legal remedy. But in case if there is a violation of fundamental rights, okay, so under Article 32, you can directly approach Supreme Court. In other cases, you first have to go to High Court. In case of fundamental right, you can go to High Court, or directly you can go to Supreme Court. In other case, first High Court, then Supreme Court. I hope that difference is very clear between 32 and 226. Now, what are the different types of writs as we discussed? The five writs we discussed. So let's get started with habeas corpus here. Now, so the five types of writs are basically habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Okay, and each of it have distinct functions and its application. That's exactly what we are going to discuss. And let's start with writ of habeas corpus. So now, what does this mean? This means produce the body. Okay, so this writ is actually used to challenge any unlawful detention. If an individual is detained without a just case, they either they it may not be possible for them to do that, or someone on their behalf can file this writ to demand their release. So the court will tell them the question, the court will ask the question of authority of the detention, and if found unjustified or unlawful, the individual is released immediately. A notable case is Rudul Shah versus State of Bihar, where the writ led to the release of a man who had been wrongfully detained for an extended period. So that is one of the case which is related to that. I'll be discussing various case laws also when we proceed with different writs. So even if there is an unlawful custody, when it comes to police also, you can go for habeas corpus. And you might have heard, you might have seen that in case of girlfriends, boyfriends eloping together, in that case also, many situations habeas corpus has been filed mostly by the girls' parents, right? So by saying that it is an unlawful detention kind of thing. So that is what habeas corpus is all about. Now, next is the writ of mandamus. Now, when it comes to writ of mandamus, it means we command. So this writ is basically used to direct the public officials or bodies to perform their statutory duties. For instance, if a government authority fails to act as mandated, a citizen can seek writ of mandamus to compel them to fulfill their duties. So you went to a village office or any, for that matter, any office, and especially if you talk about a government office or government authority. Okay, so and if he is not fulfilling the duty and not delivering his duty to you, then you can directly approach the high court, okay, and then file the writ of mandamus, and then the writ will be issued. We command, okay. The mandamus will be issued. A case illustrating this writ is when the Gujarat High Court directed a financial cooperative to release funds it had previously agreed to provide, and all those details I have discussed in the previous polity discussion. So here I am just going through the quick recap of that only. We discussed this case in detail in the actual polity classes. So the next is now a writ of certiorari. So when it comes to this, it meaning is to be certified. Okay, so this writ allows higher courts to review the records of lower courts to determine if their judgments were made in excess of jurisdiction, were unconstitutional, or violated natural justice principles. Okay, so the higher court have the power to view the lower court. Is the process has been followed, or is there any violation of natural justice? Is there any excess of jurisdiction, etc.? Now, if the lower court's judgment is found illegal, then it will be quashed. That's what certiorari. So this writ ensures that justice is upheld by allowing for the review of potentially flawed decision. For example, if you're a central government employee, you might have faced some disciplinary action. Okay, it could be legal or illegal, and there might be some loopholes, or there might not be natural justice complied. You go to CAT as you're a central government official, Central Administrative Tribunal, where maybe the judge will tell that okay, this is justified, and then he will dismiss your petition. But still, your case is very solid and clear that natural justice is not complied with. Then what you can do, you can go to the High Court and tell that yes, this is a case, natural justice has not been complied with. I went to CAT is dismissed without looking into the details of it, and then High Court can issue certiorari by quashing that order of the CAT. I hope this is very clear. Now the next is writ of prohibition. Okay, now writ of prohibition serves as a preventive function, and it stops the lower court from making rulings that may exceed their jurisdiction or violate legal principles before a judgment is delivered. What is the previous case certiorari? The lower courts made a judgment exceeds the jurisdiction. The principle, natural justice principles is not compiled with, and many cases the judgments have delivered after that you approach the high court, but this is before. So this writ is, a kind of shield against potential legal error, and it acts as a precautionary measure, ensuring that legal mistakes do not occur in the first place. Okay, so that's the prohibition, writ of prohibition. What is the next one? Next one is, okay, just 1 minute, guys. Let this complete. The ad is running. Let it complete it. All right. Okay. So now the next is writ of quo warranto. Okay. Now, when it comes to this, there's the last one, and meaning by what authority. So this writ basically questions the legitimacy of a public official's position. So if an individual is found to be occupying a public office without proper authority, the writ can compel them to vacate that position. It's a mechanism for ensuring accountability among public officials. So, for example, to hold a public office, you might have mentioned specific criterias, and the person who's holding the public office is not qualifying that criteria, then this rate will be issued. So that's about quo warranto. Now, what's the difference between 32 and 226? So I told you already, limited to fundamental rights protection. Constitutional remedy is itself as a fundamental right. So Article 32 is only for fundamental right. You can directly approach Supreme Court. Article 226 can be used for other purposes besides fundamental rights. It's not only for fundamental rights, but for fundamental rights also you can go to High Court. See, now remember, fundamental rights you can go to High Court or directly to Supreme Court. Other rights first to the High Court, then to Supreme Court. You remember the example I told you in case of disciplinary action of an employee. What This is not your fundamental right. That's a service rule. So that's a other right. You are claiming natural justice principles like that. So first you have to go to the other. Now here it's not High Court. There are other options available. Tribunal option is there. So first tribunal, then High Court, and then Supreme. Okay, so there are situations based on situations. It will be different. Okay. So we have explored 5 different writs: habeas corpus, mandamus, certiorari, prohibition, right, and quo warranto. So that's all about this session. Each writ serves a unique function in protecting citizens' right and ensure the rule of law is prevailing. And understanding these writs empowers the individuals to seek justice and reinforce the framework of fundamental rights enshrined in the Constitution. So that's the significance of the writs, and they can ask you in prelims and mains also. They can ask you. So very important. And see you guys. Thank you for attending the session. In case if you are interested in joining the complete GS course, the link is given in the description, and complete IAS course is there, and sociology optional also you can get there. So see you guys in the next video. Thank you so much.